Good morning, everybody. Thank you all for joining us today. We're almost all in from the waiting room here. So I'm going to go ahead and get us started with our Zoom housekeeping tips, which is where we usually start. So the first thing that we ask is that you stay muted during the Zoom unless you want to unmute yourself to ask a question, which you're welcome to do. Your audio button and your video button are all down on your Zoom toolbar. And so that's where you can start and stop your video or unmute yourself to ask a question. But again, otherwise, if you could stay muted, that would be great. The Zoom toolbar is also where your chat function or button is going to be. I just put a message into the chat, so maybe it's flashing for you. The chat is the best way to ask questions today or ask us to clarify something that we've said. So keep that in mind as we're going through the Q&A today. The message that I put into the Q&A does also contain both instructions for how to submit questions to us in between the Q&As. So if you have a question that you think of for next week, you email it to that email address in the message that's in the chat. It also contains a link to our YouTube channel. We post all of our videos on our YouTube channel. We also post them on our website, but the YouTube channel is searchable. If you go into not the general YouTube search, but our channel search, you can search by keywords and terms. And the videos also all contain a description with a list of all of the topics that we cover each week. And part of why I'm emphasizing this today is because a couple of the questions that we've got today are things that we've covered pretty extensively in recent videos. So to the extent that we've got repeat questions like that, we're going to just tell you the date of the video that you need to go look at so you can get the more detailed answer to the questions that we'll just cover very briefly today, since they're recent repeats. We would like to remind everybody that the chat is, like I said, intended for asking questions or requests for clarification, not for, arguments about legislative stuff or putting legal advice. So related to legal advice, we also tell you this every week, which is that we're not here to give legal advice. This is not a forum in which we can do that. So what that means is a couple of things. One is if you find yourself formulating a question and excerpting your governing documents or writing several paragraphs of detail about the situation you're asking about, that is probably going to be one of those questions where Chelsea has to email you back and say, this is too specific for the Q&A because you're asking for legal advice. Don't shoot the messenger. Chelsea's not the one who makes those judgment calls. That's me. So if you want to be upset about it, you can be mad at me. When we can, we'll try to cover the topic generally if we think that it's broadly helpful and applicable within our common interest communities here. But sometimes they're just too specific. And the other thing, the legal advice thing that I would remind you of is that if somebody sends you a link to one of our videos and says, you have to do this thing because of something that Valerie or Ken or Tima or whatever said during the Q&A, you can ignore that. Maybe what you do is treat it as a cue to check in with your association attorney about whatever the issue is. That person is telling you that you have to do something or you're not allowed to do something because of something that we've said here. But again, we're not here to give legal advice. That's not what we do in this forum, so please keep that in mind. Speaking of our Q&A videos, one thing that we've been doing since the legislative session is doing little primers where we'll spend maybe the first 10 minutes of the Q&A talking about some of the upcoming legislative changes that we're all going to be dealing with in Washington State here pretty soon. And so if you look at our recent Q&A videos, you'll see that we've done primers on things like the upcoming changes to the meetings statutes, the upcoming changes to the delinquency notice requirements, and other things like that. So if you are curious about some of these legislative changes and how they're going to impact either your community or the communities that you serve, if you're a manager, look at our videos recently and check out those primers. Hopefully they'll be helpful to you in educating everybody, all of ourselves, on these changes that are coming down the pike. We also want to remind everybody that CA Day is coming up on October 18th. And I don't know why. It just feels like when we first started announcing this, I was like, that's months away. Why are we even announcing it? And here we are almost halfway through August. So CA Day is coming up on October 18th. We're going to have a booth. We would love it if you would come to the event. It's an excellent opportunity for both networking and educational stuff. And Katie is going to be presenting, co-presenting with Michelle Weaver about the upcoming changes to the meeting statutes. So if you've been curious about and wishing that we could talk more in detail about that particular topic, there will be an excellent presentation on that at CA Day in October. And finally, this is probably going to be our last reminder, I think, but please do note that to the extent that there were changes made to WUCIOA as it governs WUCIOA communities now, those changes took effect on July 27th with very few exceptions. So to the extent that you're dealing with a WUCIOA community or you're living in a WUCIOA community, just make sure that you're looking at the current version of the statute, because there were changes that took effect in July of this year for communities that are currently governed by WUCIOA. I think that's all of our announcements, so I'm going to go ahead and jump into our first question. And again, if you have questions that you did not submit in advance, please feel free to pop those into the chat. We'll try to get to them at the end if we've got time. Here's our first question. Our HOA governing documents are silent on any requirements to provide notice to homeowners for board meetings. Can we comply with the notice requirement by posting a meeting notice 14 days in advance with the agenda at our communal mailbox stations? The short answer to this question is that no, you cannot. Posting a sign or a notice by the mailboxes does not satisfy the statutory notice requirements. Your documents might be silent as to what notice is required before your open board meetings as an HOA, but the statutes are not. And by statute, there are a few acceptable methods of giving notice officially to your owners, and those include sending the notice by mail. They include hand delivery to the owner, not just to any old occupant of the home. And they include electronic notice if an owner has opted into receiving electronic notice. So if an owner has not opted into receiving electronic notice, you can certainly email them notice of the board meeting, but that's not going to qualify as notice under the statute unless they have opted in. And I think it's important to note that there are court cases in other states that have ruled that failure to give notice to the owners of a board meeting is a failure by the association to comply with the open meeting requirements that are in the statute. So we think this is a pretty significant failure, and that you need to be as proactive as possible about complying with the notice requirements in notifying your owners of open meetings, right? Because how can you call it an open meeting if owners don't get effective notice? The other thing to note is that the WUCIOA meeting section, which is RCW 6490-445, is going to be effective for all communities in Washington State beginning on January 1, 2026. And it does provide for a shortened notice period for unforeseen circumstances when giving 14 days notice is not possible. So you'll want to review RCW 6490-445. And this is true for everybody, regardless of what type of community you are in or what you're managing. You should all review that statute and the changes that are coming to that statute in January, because that will apply to everybody. January 1 of 2026. And another section to be aware of is the emergency section under WUCIOA, which is RCW 6490-502. That section was not amended this year. So if you were like skimming the text of the WUCIOA trailer bill, you might be confused why I'm mentioning it, because it was not amended this year. But because the WUCIOA meeting section is going to be made applicable to everybody in January of next year, this section is also relevant because it talks about notice and how an emergency plays into the amount of notice that you have to give, the type of notice that you have to give, etc. But please do note that it very specifically defines emergency. And over the years, one of the things that I've learned is that we all define the word emergency differently. The statute is really specific about what constitutes an emergency. And most of the things that my clients have considered an emergency over the years would not qualify as an emergency under this particular section of WUCIOA. So I think that answers the question. Tima, if you have anything to add, please feel free.
Yeah, Valerie, the only thing I would add to that, and maybe it goes without saying, is as long as you're following the statutory requirements, it's not a bad idea to post a sign by the mailboxes. I mean, certainly that's a wonderful way to remind people of what's going on, but we're just letting you know that that doesn't satisfy the statutory requirement. So just because, but that's not a bad idea. Sure. That way people know and are reminded of the fact that there is an upcoming meeting. Okay, I'm going to move on to the second question. Is it legal or advisable for an association to have a rule that establishes a juvenile curfew for their common area, which include being out on the private roadways? So before we delve too deep into this question, I will remind everyone that we did answer this question on July 30th, so you can go to our YouTube channel and look that up if you want a more detailed answer. The short answer to that question is probably not. There are going to be exceptions, but any age-related restrictions are likely to violate the federal law, specifically the Fair Housing Act, in which children are a protected class. So they treat families with children cannot be treated differently than families without children. So you want to keep that in mind. There are going to be some exceptions. For example, one notable exception would be children under 13 swimming without adult supervision. That would be a major safety concern. So the bottom line is, what is reasonable and what is legal are not always going to be the same thing. And it's a good idea to consult your association attorney to confirm with them any type of changes you might be implementing, and to look at and to first to draft those rules and to ensure or community policies that have any type of restriction relating to children to make sure that those are in compliance with state and federal law. Valerie, did you want to add anything to that?
Yeah, the only thing that I would add is you can regulate the activities of your residents in general. You just can't target children. So I guess part of what I would want to know if I had a client asking me this question is, what is it that you're trying to accomplish? Is it noise related? Is it kids screaming, playing basketball during the summertime at night? Is it whatever the issue is that you're trying to address is likely to be something you can address without adopting a rule that targets children. So it could be something where you're regulating noise, where you're regulating activity in the common areas by all residents, right? And that would include the children. So that's the question I would have for a client coming to me with this issue.
Yeah, there's probably a way to achieve your objective without violating state and federal law, but
Yeah.
it's all about the language and the wording that you're using in these policies. So before you put something in print, you'll want to make sure that it's in compliance with state and federal law.
Exactly. All right, moving us to the next question. If an owner writes paid in full or something similar on their check and the association cashes it, is that a legal admission by the association that the account is settled in full, even if there is still a balance owing? The answer to this question is not black and white. It's not clear. So the answer is maybe, and it depends on a number of different circumstances. I will start by saying that this is all related to the full accord and satisfaction doctrine, which stands for the proposition that if a person that owes a financial obligation tenders payment as full satisfaction of the balance due, and if that payment is deposited, then the claim is discharged. And I'm using my air quotes here because this is language straight out of the statute on full accord and satisfaction. So this just means that the payment in full language under those circumstances could be binding on the creditor. It is, however, not automatic that depositing the payment that says payment in full or something similar to it would wipe out the obligation to pay the rest, but it just makes everything more complicated, right? The payment or the accompanying letter has to have a conspicuous statement that it is intended to be payment in full. So if it was in small print on a bank generated check or buried in a letter, the outcome might be different than if it was, a handwritten check where payment in full was all in caps on the memo line. And the language also matters. So if it says payment in full, that's very clearly supposed to be payment in full. If it says full satisfaction, I think the outcome is more likely to be in one direction. If it says something like 2024 assessment balance or unpaid dues or something a little bit more ambiguous, then I think it's a murkier question to analyze. I also would like to point out that if the owner knew that they owed more than that and they were trying to wipe out their additional balance due in bad faith by writing payment in full on a check, even though they know full well that it's not payment in full, the outcome, if a court were deciding this, is unlikely to be that, you can't just, you owe somebody $10,000, you write a check for 50 and write payment in full. That doesn't wipe out the rest of the 10 grand under many circumstances. But as you can probably guess from all the different examples and the, well, if this, but what if that, that I'm going through, this is just kind of a complicated question. So for example, when we have an account in our office, when we're trying to help an association get an owner to catch up on their past due assessment balance, we specifically request that any payments received by the client or the management company, they just scan and email us a copy before they deposit them. Because we don't want to create the sort of confusion and the murkiness and the challenge of trying to figure out, well, does it count as full accord and satisfaction? Does it not count? What do we think a court would say? Most of our clients don't want to be a test case in court, right? Because that is time consuming and expensive and annoying. And so we ask that we have an opportunity to review all payments before they're deposited when they're received on an account that we're handling in our office. I also think it's worth mentioning that there is also a case law in Washington. Actually, it's not case law, it's a statute that says that if the creditor deposits a payment that's marked in this way, payment in full, and refunds the payment within 60 days of depositing it, it basically undoes any full accord and satisfaction effect that might have been created by depositing the payment. So again, all of this just means the situation is not as clear or straightforward as we might like it to be. An owner can't write payment in full on a check when they fully know that they owe more than that to wipe out the entire obligation. But it does give them an argument that they can take to court. And a really big part of our job is helping our clients stay out of court for so many different reasons. So my recommendation would be that if you get a payment that says something like this on it, run it by your association attorney before you deposit it, even if the account isn't in the attorney's office. I have clients email me questions like this all the time. I'm more than happy to take a look at a check and tell them whether there's risk associated in depositing the check or whether they should return it to the owner and ask the owner to submit the check again without the restrictive endorsement on it. So, Tima, did you have anything you wanted to add to that?
I mean, I would just say that, it's not like we're not looking for restrictions. If we're not trying to not deposit checks, it's that we have to look at them from from a very specific angle when we have an account in collections. And it's just an added measure for our clients to ensure that they're not going to, like, as Valerie said, face some type of scrutiny down the road. And for the record, I mean, rarely does that actually happen. I mean, very rarely do we actually reject a check. It has to be very clear circumstances. And in fact, I've had situations where I'm not exactly sure, and then I'll consult with Valerie or Lisa, someone else on my team, to say, is this because it's mostly gray area. Very rarely is it clearly a check that we're not going to deposit. So anyway, I just thought I'd add that it's not a common occurrence. Okay, question 4. Our governing documents state we can record a lien 30 days after an assessment is due if not paid. However, the statute, the 6438-100, the statute that covers pre-foreclosure notices, says nothing about when we can record a lien. And many are saying it's 90 days after the due date per 6438-100, stating that we have to send out all pre-foreclosure statements first. We disagree, but we want to get more input. Can we follow our governing documents to record a lien anytime after the 30-day due date, or is there other guidance that we need to be following? So the answer to your question is yes, you can follow your governing documents. In this situation, there is no restriction in any of the statutes as to when a lien can be recorded. And, just to put some perspective on it, a lien it's just a public record that puts everyone, including the owner, on notice and any other lien holders that there's an outstanding debt tied to the property. Recording a lien and enforcing a lien are not the same thing. So, recording lien is in this situation completely advisable and legal. So I don't see any restriction that you would need to be aware of in this situation. Valerie, did you want to add anything to that?
It did just occur to me that effective January 1, 2026, the delinquency notice requirements might change this. It might change the answer to our question. So, and we're going to talk a little bit about this more in detail later in the Q&A today. But in January 1, 2026, all of the common interest statutes are going to be modified to require that you send written notice to a unit owner, a lot owner, whatever, of their delinquency no later than 30 days after the account is delinquent. And you have to then wait 15 days minimum after mailing that notice before you can take any other collection action, including recording a lien. So in a scenario where you're in, let's say we're talking, let's just throw out some imaginary dates by way of illustration. Right now, under your governing documents, if somebody has an assessment that was due on January 1st and they didn't pay it, and your documents probably say something like an assessment is delinquent if it's not paid on the date that it is due. A lot of people think it's not late until the late fee date. That's a grace period, but it's usually late the date that it's not paid when it's due. Your current timeline would look like 30 days later, so January 31st, you could technically, under your current documents and statutes, record a lien as long as you comply with any notice requirements that currently exist in your CC&Rs or your other governing documents. Effective January 1st, 2026, you will be prevented from recording that lien until 15 days after you send a delinquency notice that complies with all of the new statutory requirements. So you might be looking more, unless you're going to send the delinquency notice on January 2nd, you're not going to be able to record that lien on January 31st or February 1st. You're going to have to wait until at least 15 days have passed after you've sent the delinquency notice. So if you send it January 15th, then you might be able to go ahead and record at the end of January or early February. But if you don't send the delinquency notice under the statute until February 1st, then you have to wait 15 more days before you can record the lien. But again, that's a change that's coming in January that's not currently in effect. But I mean, we're only 5 months away from there. So it's worth starting to adjust our thinking on this stuff now.
Okay, next question. For 55 and over communities, is it specific enough for a signed affidavit to state that the resident is 55 years of age or older? Or do we need to require the actual age or birth date of the resident? To answer to your question is yes, a signed affidavit is sufficient under the CFR section 100-307, which requires that any documents that are considered reliable documentation of the age of occupants of the housing facility or community include a certification in a lease application, and affidavit is an included measure. Or any other document signed by any member of the household age 18 or older that is asserting that at least one person in the unit is 55 years of age or older. So you can look that up more specifically, but the answer to your question is yes. And I would add that another portion of that regulation states that a facility or community shall consider any one of the forms of verification identified above, meaning the ones I've already mentioned, the lease application, affidavit, or signed document. Those are considered adequate for verification of age. So that's a simple answer, I suppose.
All right, I'm going to move us on to our next question. This starts by saying, thank you for the great summary in the July 30th Zoom meeting about changes to the meeting statute effective January 1, 2026. Are there any additional changes pertaining to running meetings that also go into effect that date for communities that are not currently WUCIOA communities? In particular, will there be a requirement to enable telephonic, video, or other conferencing processes for board members and unit owners, or is this just an option? What if a board member or unit owner requests or demands attending electronically after that date? Would we have to provide that ability? We are a small community and we are trying to determine what we will need to do in order to be ready for the changes coming January 1, 2026, such as setting up a Zoom account, getting Wi-Fi, etc. So the entirety of the WUCIOA meeting section is going to be applicable to all communities. starting January 1 of 2026. So all of the things that we covered in our primer on July 30th are going to be applicable to all communities, even those that are not currently governed by WUCIOA. However, there is no requirement that association or board meetings must be conducted electronically or virtually or telephonically. It's just an option under the current statutes. However, the legislative intent is absolutely to encourage participation by allowing multiple means of attendance and participation by both board members and unit owners. So if a board member were to request electronic meetings or a telephonic attendance as an accommodation for a disability, for example, we would probably tell our client that they needed to comply with that. And then I also, again, like I think you probably hear Ken and I say often, we're always curious about sometimes what's the impetus behind a particular question? Because I would want to know why an association would refuse to allow a board member to participate by phone. And so if you're conducting a board meeting and you still do all of your board meetings in person, but a board member is out of town or injured or sick and they still want to participate, I don't know why you wouldn't call them up on your phone and put them on speakerphone and let them participate telephonically. Having the non-in-person option does not always require that you have a paid Zoom account, that you have high-speed Wi-Fi. Sometimes it can be as simple as letting somebody call in and putting them on speakerphone so that you can establish quorum, so that you have the input of all of the board members or as many of them as possible. And I did have a client, this question reminded me of a client that I had that was insistent, even up until maybe a few months after the COVID emergency orders allowed virtual meetings. But they were adamant that they wanted their board members to attend meetings in person, and they wanted to make it a requirement or essentially a bar to service on the board if a board member would not agree to attend every single board member meeting in person. They just were vehemently opposed to conducting board meetings virtually or allowing telephonic attendance. And I still don't understand why that was the case in that community. And part of what I would ask a client that was asking me this question today is why wouldn't you try to make it as convenient as possible for your board members to attend a meeting, even if that meant allowing them to call in and putting them on speakerphone? Does not necessarily mean that you have to offer a virtual option for every single one of your meetings, but I would just say be reasonable in responding to requests to attend virtually or remotely, depending on the circumstances. And if you're ever in doubt and you're wondering why, what to do or how to handle a request like this, then I would say you should absolutely consult with your association attorney, because like I mentioned before, if there's ever an actual accommodation request around these things, you want to be really careful about how you respond. So legislative intent is to encourage participation and to make it as easy as possible for people to observe and attend meetings. Zoom is really easy to set up, really easy to administer. You don't have to pay a single dollar for small meetings. I'm a really big fan of virtual meetings. So in my personal opinion, you should do what you can to allow and facilitate this option, but it's not going to be required by statute unless, again, you're dealing with an accommodation request, and in which case you should consult with your association attorney so you can respond appropriately. Tima, did you have anything you wanted to add to that?
I don't think so.
Okay.
I'm going to move on to question 7. When posting board minutes for owners or sending with a resale certificate, should the reports and other materials in the board packet and available to owners at the start of the meeting be included in the minutes? Are they required? And then the caveat is any materials for an executive session are available only to board members. So we're just talking about open session. So the answer to the question is no, not necessarily. The statute doesn't have any specific requirement that you have to actually include the materials referenced or reports referenced during the meeting in the minutes themselves. They don't need to be attached to the minutes. But the minutes must specify the action that was taken with regard to those documents. So as long as the documents themselves are properly referenced in the minutes, you've satisfied the statutory requirement. That being said, if an owner requests them, they should be provided to an owner. So as long as they're properly referenced, like I said, I think that you're satisfying the statutory requirement. And then if that triggers an owner to ask a question, hey, I'd like to see that report that was mentioned in the minutes, that's something you can provide. And specifically, looking at all the statutes that are currently still in effect, the specific language about retaining documents is the same for all of the statutes. It says that an association must retain the following: minutes of all meetings of its owners and board, other than executive sessions, a record of all actions taken by the owners or board without a meeting, and a record of all actions taken by a committee in place of the board on behalf of the association. Valerie, did you want to add anything to that?
Nope, you covered it.
Okay, we have question number 8. Can you confirm the requirement for an association to have separate insurance accounts for the premium and deductible? We all recall it, but I can't find it now. So the answer is that there is no statutory requirement that you have a separate account for insurance premiums or deductibles. That is not a statutory requirement. So you'll want to look to your specific governing documents in this case as to what types of requirements there are in place. Specifically, WUCIOA requires a separate reserve account to be controlled by the board. And specifically, some declarations that we've seen require an insurance reserve account. But we have not seen any that require separate accounts for premiums and deductibles. We haven't seen that. So that's not something that we commonly deal with. And I believe that answers the question.
Yep.
So our third question number 9 is, are proxy votes allowed for budget ratification? And the short answer to the question is yes, unless the governing documents state otherwise. So specifically, the statute says that unless the declaration or bylaws otherwise provide, unit owners or their proxy holders may vote by voice vote, show of hands, standing, written ballot, or any other method authorized at the meeting. And then more specifically, in 649525, unless at that meeting the owners of the units to which a majority of votes in the association are allocated in any larger percentage specified in the declaration reject the budget and the assessments against the unit included in the budget are considered ratified, whether or not a quorum is present. So the general rule, again, in this case, yes, voting by proxy is permitted, but most of our clients do not provide a proxy in their meeting packets for a budget ratification meeting. They will sometimes if you're having your annual meeting along with the budget ratification meeting, but one thing that we have noticed is that by adding a proxy, it can make it easier for owners to actually reject the budget. So sometimes, it's not that we don't recommend it, but it's just it's a practical consideration when you're including proxies that you might want to keep in mind. If an owner shows up with a proxy that complies with the statutes, you need to allow them to vote by proxy, however. And I think that covers it. Valerie, did I miss anything in there?
Nope, I think you got it.
Okay.
I'm going to move us on to our next question. I hope this is relevant for the Q&A. What qualities, exempt an HOA from implementing WUCIOA? Size of the number of owners in the HOA monthly dues, etc. So I would like to point you towards our Q&A video from July 9th when we covered this in more detail. But to qualify to opt out of WUCIOA, a community must have fewer than 50 units and must charge less than $1,000 per unit per year in assessments. If your community meets those criteria, you might be able to opt out of some WUCIOA requirements, but not all of them. In fact, 74 sections of WUCIOA will still apply even if you opt out. And those include board meetings, notice and quorum sections, voting procedures, budgets and reserve studies, reassessal certificates, rules adoption and enforcement, financial reporting and records access, etc. So By opting out, you might think that you're opting out of the whole statute, but you're really only opting out of part of the statute. And there are 74 sections of WUCIOA that will still apply even if you do opt out. So if you look at RCW 6490-360 subsection 4A, that will give you a list of all of the sections of WUCIOA that would still apply to you even if you opt out. Generally, the full statute provides for more protections for individual owners. And of course, the flip side of that is that it does create a little bit more of an administrative burden and therefore sometimes cost for the association as a whole. So the cost benefit analysis is a big part of how you decide whether opting out is the right decision for your community. But we would strongly recommend that you consult with your association attorney to discuss the pros and cons for your particular community of opting out, even if you do qualify, because your attorney might have some, if you, for example, go to your attorney and say, we're thinking of opting out, we have fewer than 50 units, our assessments are under $1,000 per owner per year, and here are the top 3 reasons why we want to opt out. And your attorney might look at the sections of WUCIOA that are still going to apply to you anyways and say, well, all 3 of those reasons are not going, you're not going to get what you want by opting out because all 3 of those reasons are still included on the list of sections of WUCIOA that will apply to you anyways. So that is an analysis that you need to do with your association attorney in order to determine whether you can opt out. Tima, did you have anything else you wanted to add to that one? Oh, you're muted.
Sorry, I just muted myself by accident. No, I don't. I think that answers the question.
All right. Okay, and I'm going to jump us to our next topic, which, as promised, is related to the changes in delinquency notices and late fees and such that are coming in January of 2026 for all communities in Washington. So the question that was submitted is this: is it the intention of the new law that allows a late fee of 5% of the balance due up to $50 plus admin fees to replace all pre-existing late fee policies or to add to it? Our understanding is that the original $25 late fee, for example, can only be charged 15 days after the notice of delinquency that's required by the statute is sent. So I'm going to again point everybody to the July 16th Q&A video because we did a primer on these statutory changes surrounding delinquency notices and late fees and such. Again, these changes go into effect January 1 of 2026. But the short answer to this question is that no, the late fee language in the statute does not replace a pre-existing late fee policy. It just creates a statutory maximum for your late fee until you have complied with the delinquency notice requirement. I would also like to point out that you are not required to increase your late fee in order to charge $50 or 5%. That is simply the maximum that you can charge for the first late fee and until you've complied with the delinquency notice requirement. No additional late fees can be assessed in any amount until 15 days after the delinquency notice required by the statute has been mailed. After that time period has passed, your normal late fees, whether they're $25 or $50 or $100 a month, whatever they are, your normal late fees will apply. I do want to clarify something too, based on the wording of this question, because the question said that we're talking about a late fee of 5% of the balance due, and it's not 5% of the balance due, it's 5% of the unpaid assessment. So let's say you're an association that charges monthly assessments of, $500. You're calculating 5% of that $500, which is your maximum late fee. It's either $50 or that 5%, whichever is lower. It's not 5% of the, $500 assessment and the $100 fine from last month because they had garbage on their balcony and late fees and interest from a previous balance due that they never paid off. So it's not 5% of the balance due. It's just 5% of the missed assessment. So I just want to emphasize, this does not override your current late fee policy. All it does is set a statutory maximum late fee that you are not required to charge the full amount of. It just sets a maximum. So this maximum, this language is really more for those communities that, for example, maybe charge a $100 per month late fee, but their assessments are $500 a month. Because in that scenario, your cap would be lower than the actual late fee stated within your policy, right? Because you'd be limited to that $50. You do not have to charge the $50 or the 5% if it is higher than what your current late fee is in your documents. You don't have to adopt a new collection policy or late fee policy. However, what I will say is a lot of our clients are choosing to adopt a new collection policy now anyways, because a lot of the collection policies that were written before these changes were known don't have timelines that comply with these notice requirements. So you might want to consider having your association attorney draft you a new collection policy, not for the purpose of increasing your late fee or anything like that, but simply to make sure that your policy and your timelines are consistent with the statutory notice requirements. And I will just really quickly, very quickly, I want to go through and recap the changes and the requirements under this new statute that is going to take effect next year, January 1. What it does is it adds a delinquency notice requirement and it creates penalties and consequences for failing to comply with those notice requirements. So within 30 days of a delinquency arising, an association must now notify the owner in writing, and the writing has to include a copy of the pre-foreclosure notice of delinquency, which that's been required for a long time. Not everybody's been doing it, but this is your reminder that it's really important to include a copy of that statutory pre-foreclosure NOD now in the first notice to the owner that their account is delinquent. The notice has to also include the delinquent amounts and a statement that the account is past due. The notice has to be translated into the owner's preferred language if they notify you of that preference. It has to be mailed to the address within the community and to their offsite mailing address if they have an offsite mailing address. And that's true even if you know they don't live in the community. So even if the unit is rented, even if the lot or the house or whatever is rented, you still have to send this first notice of delinquency under the statute. It has to be mailed to the community address and to their offsite mailing address. You also have to email it to them if their email address is known to you. And this is true even if they have not opted in to receiving electronic notices for from the association. And then you have to keep a copy of the notice that you send. So whatever the packet is that you send, it's going to probably look like a cover letter that includes a ledger. It includes that pre-foreclosure NOD form. You got to, and whether it's translated or not, whatever that looks like, you need to keep a complete copy of that notice that you send because that's a new requirement in the statute. I also would like to point out or remind everybody that when an account becomes delinquent might not be when you think it becomes delinquent. A lot of people assume that, well, the late fees are charged on the 15th, so that's when the account is late. Most documents state that an assessment is late when it's not paid on the day that it's due. And the reason this matters is because you have a maximum of 30 days from the date of delinquency to send a notice that complies with these new statutory requirements. So if you're assuming that it's not delinquent until the late fee is charged, you might be off by 15 days or however many days your grace period is. Also keep in mind that until you send the notice that's required by statute, you're limited to that one late fee of no more than $50 or 5% of the unpaid assessment, whichever is lower. You can also charge the owner the actual mailing cost for the delinquency notice, and you can charge them one $10 admin fee for sending the notice. Once you've sent the notice and 15 days have passed, then all of your normal options come back into play. But until you send the notice and wait 15 days, you cannot charge additional late fees. You cannot refer an account to an association attorney. You cannot record a lien. You cannot take any of the normal collection options that you would ordinarily have or assess any costs to the account until 15 days after you've mailed the notice that complies with the statute. So I think that that is a good enough sort of recap. I don't want to spend 20 minutes on it when we just did that a few weeks ago. Again, I will refer you back to the July 16th Q&A video on the YouTube channel where we went a lot more into detail in with all of this, but hopefully that answers the question. And Tima, did you have anything you wanted to add?
I would only say there was a follow-up question just to acknowledge that we
Oh yeah.
received one, which is if the HOA implements the 5% up to $50 late fee under the new law, does it require them to update and publish new late fee rules? I think we've addressed that already. It's not a bad idea to update your collection policy, but as a rule of thumb, if the 5% or $50 amounts to an increase in what you're currently assessing to owners. So if, in other words, if your late fees are $45 or 40 or 35 and you're applying 50 now, that is something you're going to need to give notice to the ownership about. If the 5 or 50 is less than what you're currently assessing, you would not need to give notice to the owners. But regardless, it's not a bad idea to have your association attorney ensure that the policies that you have in place are matching the practice that you're actually, you know, that you're actually practicing. So I think that was our last question.
It was our last question. So I'm going to just say one other thing on that topic, and then if any new questions come into the chat, we can answer them, and if not, we can be done. But the other thing that I will offer is that we do have clients that just had a collection policy drafted 3, 4, 5 years ago, and they're choosing to have a new collection policy drafted now so that their timelines and procedures are consistent with these new notice requirements. And it is not uncommon for me to see collections policies or rules that have, 2 paragraphs about late assessments or whatever that are 10, 15, 20 plus years old. So if your current collection policy or late fee related language is in a document that's older than just a couple few years, I think it's worth having your association attorney at least look at it and tell you if it should be updated. And I think most of the attorneys in our practice area do a pretty reasonable flat fee for a collection policy. I know ours is $450. So it's not a hugely cost prohibitive piece of work to have done. And keep in mind that depending on what statute you're governed by, either the board has the authority to adopt the collection policy without a vote or notification to the owners, and then you have to publish it to them in order for it to be enforceable. Or if you are a community that's currently governed by WUCIOA, you would treat this like you're changing your rules, which the statute for WUCIOA requires that you send out notice of the proposed change to the ownership, allow for a reasonable amount of time for the owners to comment on it, and only after receiving those only after owners have been given that meaningful opportunity to comment can the board vote on and implement the new policy. So keep that in mind. And, I did realize that there are a couple of follow-up questions in the chat. So one of them says, if the board is allowed electronic attendance, doesn't that mean all owners must have the same access? And I think the answer to that question is that it depends. If you are conducting an in-person board meeting, but a board member asks for the opportunity to call in because they're in Italy or because they're in the hospital, so they can participate telephonically and not have to miss the meeting as a result of whatever is going on, I don't think that automatically means you then have to offer that option to every owner. The owners have the right to observe that meeting in the same way as they always do, which is come to the meeting in person. If an owner requests an accommodation and asks for the opportunity to observe the board meeting virtually or telephonically because of some other issue related to, to their ability to attend in person, then I think you respond to that on a case-by-case basis, keeping in mind what we talked about with respect to whether it's an accommodations related request or just a convenience related request. There's another follow-up question in the chat that says, does opting out also apply to common interest communities that are fully commercial properties? Janice, I would have to look that up. I don't know that off the top of my head. So I'm going to have to look that up, and we will put that. Chelsea, will you put that question on the list for next week, please? Thank you. Tima, did you have anything you wanted to add, or are we just going to wrap it up? Because I am not seeing any other questions in the chat right now.
I don't think so. I think we've covered the bases, and just remember that we've referenced some former Q&As. So if you want to go deeper into some of these topics, You can look back at our Q&A for some of the primers we've been doing. But thanks for being here.
Yeah. Thanks, everybody.
Have a
See you
great
next
day.
week. Bye.